his topic today is going to be about mediation.
Thank you, Brian. That was a very warm greeting. It's always great to be back here at the Western Gabriel Valley Association of Realtors. I've been a member for, I think, over 20 years. I first started as a realtor, so I'm just like one of you. I consider myself part realtor, part lawyer. And I remember back then, in the 90s, the Bureau of Real Estate was called the Department of Real Estate. Well, I just found out today that they're renaming it back to the Department of Real Estate starting in July of next year. And if any of you are planning to print business cards, I suggest that you wait because you're going to have to change it from BRE to DRE. A little bit about myself. Real estate was my passion. I first started in real estate as a real estate broker in 1993. And throughout the years, I would be involved in real estate matters. And during that time, I would encounter a lot of legal disputes, which led me into the practice of law. So I became an attorney in 2001, and I've been practicing real estate cases the majority of my time. What I want to talk to you today is about mediation. So I just kind of want to get a sense here, how many people have been involved in mediation in the real estate area. Could you raise your hand if you've been involved in mediation? You guys see about 1, 2, 3, 4, 5, 6. And those of you that have been involved in mediation, how many of you have retained attorneys during the mediation process? Okay, so 1, 2, 3, 4. And how many of you were successful in the mediation in resolving the dispute? 1, 2, okay? And those of you that were successful, how many of you eventually earned your real estate commission? Only 1, 2 again, okay. So, those of you, that,
Can we put the PowerPoint? Oh, they're gone.
sorry,
Straight.
I clicked the wrong button. Those of you that didn't raise your hand, you're very fortunate because
Push this to advance.
Because you didn't have a legal dispute in your transaction, which meant that you closed your sale successfully, you earned your commission. Okay? Those of you that did raise your hand, that did go through the mediation process, you're one of the few. Because having a real estate dispute in a real estate transaction can be very time consuming. So before I begin my topic, I'm going to go through some of the important aspects of mediation, what you need to pay attention to, okay? I'm going to go ahead and read a legal disclaimer. This is just something I need to get out of the way. All information provided at this seminar is based upon California and U.S. federal law and for informational purposes only. No information presented constitutes legal advice. Your attendance does not create an attorney-client relationship. All attendees will not have their legal problems resolved, and answers to questions do not constitute legal advice because the speaker, that's me, does not have all the time to analyze the case. The opinions expressed at the seminar are my personal expressions and do not reflect the opinions of other attorneys. All right, so I've got that out of the way. Abraham Lincoln is one of my favorite presidents. Abraham Lincoln was the 16th president of the United States, and he once said that a good settlement is better than a good lawsuit. So the vast majority of civil cases are settled, which basically means that mediation does work. And here in Los Angeles County, we are the most litigious part of the country. There are more lawsuits filed in LA County than in any other part of the state. And it could be that maybe there are a lot of attorneys, but at the same time, there are a lot of disputes as well. The majority of cases don't go to trial. About 90% of the cases end up getting settled, either in mediation or through arbitration. So the widespread acceptance of mediation shows that it's a superior form of dispute resolution. Now, mediation is not litigation. So a lot of people go into mediation thinking, I'm going to win, but that's not the case. Mediation is basically a compromise. Okay? Every successful negotiation requires that you have a sound strategy. So there are 12 essential steps to a successful negotiation in mediation. the success or failure of a mediation depends on who the mediator is and how and what is the mediator's experience. So before retaining a mediator, you need to find out as much as you can about their qualifications and experience and methods. The evaluation of a mediator will help you determine whether or not that person is right for your case. First of all, you need to hire the right attorney to represent you at mediation. This is very important because, like attorneys, there are many specialties. Just as you have doctors that specialize in heart transplant, surgeries, you have gynecologists, pediatricians. With lawyers, we also have different types of areas of law. There's immigration law, personal injury, family law, business, corporation, real estate, so on and so forth. So the first thing you need to find out is that attorney experienced in real estate matters? There are some attorneys that handle everything. We call them jack of all trades. But that doesn't necessarily mean that they're experienced in the real estate setting. And you have to pick the right time to mediate. What does that mean? That means that in the RPA, there is a specific provision in there in the dispute resolution clause. Most of you have already had this training. I'm sure Bill Hutchinson has gone through the legal updates with you, and your broker has given you seminars on the RPA. So the right time to mediate is when both sides have a disagreement they cannot resolve. Think of mediation as a form of a marital dispute. Okay, you have a husband and wife, they have a disagreement, and they have to go to a marriage counselor. Well, the same is true for mediation. You have a buyer and seller, they have a disagreement over the contract, and they can't resolve it, and they need a third party who's neutral to try to get both sides talking and hopefully resolve the matter. Now, when you go into mediation, you have to have the right mindset. Many people expect mediation to be like lawsuits going into a trial, but that's not the case. And mediation is considered to be a very informal process, which means that there's no judge, there's no jury, there's no bailiff, you're not in a courtroom. You're usually sitting in a conference room somewhere in an office building. And the mediator is usually a retired judge or a real estate attorney that has at least 5 or more years of real estate experience. Choosing the right mediator is very, very important to a successful mediation. The reason I say that is because the mediator has a lot of influence over both parties. His job is to try to get both parties to compromise. And the key word here is to compromise. Many mediators who don't have enough experience don't know how to convince people to compromise. You need to pick a mediator mainly that has been doing real estate cases very, very often. And how do you know if a mediator is good? Well, there are 2 ways based on my experience. Number 1 is the most expensive mediators tend to be very good because they can command that much money. They charge anywhere from $500 to $600 per hour to mediate a case. So both sides could end up spending about $5,000 just to mediate a dispute. The second way of finding out whether a mediator is qualified is you look at his background. You see how long he's been practicing, how many cases he's resolved successfully, what type of cases he's handled, what other clients say about him, so on and so forth. Now, there are some retired judges that are also very good mediators, but you have to be careful with retired judges because they don't tend to update themselves on the law after they retire from the bench. So from my own experience, I tend to like real estate attorneys that are currently practicing because they're still aware of the changes in the law. And as you know, laws change every year, new cases come out. So picking the right mediator is the key to a successful mediation. Now, once you pick the right mediator, the next thing you need to do is have pre-mediation conferences. What that means is that you need to meet with your attorney and your client, whether it's the buyer or the seller. This is very important because you have to prepare yourself mentally for the mediation. The mediation usually lasts a whole day or half day. So a whole day of mediation would be 8 hours, half day would be 5 hours. And during this mediation process, you need to know what to say, how to say it, and what to say to the mediator so that he can convince the other side why they should settle. Now, as I mentioned before, mediation is a compromise. Don't expect to win the case. You'll be lucky if you come out with just half of your demand, whatever that amount is. Another factor is to set aside sufficient time for the mediation. Because mediation takes about a day, what you have to do is plan your schedule accordingly. So if you have open houses, or you have to do inspections, or sign loan docs, so on and so forth, just make sure that you plan the right amount of time for the mediation. Normally mediation will last a day, but I have been in some mediations where they've lasted 2 or 3 days. And depending on how the parties behave during the mediation, the mediator may end up continuing the mediation for another week or so. But in the vast majority of the real estate disputes I've handled, most of the mediations are resolved in 2 days or less. If you need to be out of the country or your client cannot make it, try to schedule it so that everybody is available. Prepare your case well. I cannot stress this enough. When I say prepare your case well, that means that as realtors, all of you should have a log, which basically says what you've been doing in the transaction, who you've been talking to, what documents were signed on which day. Unfortunately, in this technology age, a lot of documents are e-signed. So half of your job is already done. You can just go into the computer and find out when the documents were signed, how were they signed, so on and so forth. But what I've discovered in my practice is a lot of agents, they don't keep a log of who they call and what they discussed. So it's very important that you try to keep a journal of your conversations with your clients, because maybe 6 months later you forgot what your client told you, or they may say that the seller told them something, and that key information was very, very important to the case. So it's very important that you prepare your case well, have a chronology of events so that you can present to the attorney. I have to stress this factor is that a lot of times when we handle these types of cases, the clients, whether it be the buyer or seller, would just come in and say, I don't have anything, my agent has everything. And then I would call the agent into my office, and the agent says, well, I thought the seller had everything. In that kind of a scenario, it's very hard for the attorney to piece together the facts. And so, as I stressed to you today, it's very, very important that each one of you have a journal. At least have something in your computer which shows a record of the transaction. Now, this is our job as a real estate attorney. We have to prepare a very strong mediation brief. The reason being is that we want to convince the mediator that we have a strong case, and that if the other side does not settle the case, we're prepared to go to trial, and we're prepared to win the case. By preparing a strong mediation brief with case law, citations, and other factors, we can try and leverage as much as we can during the mediation. A lot of times, both sides will go into a mediation and they will both feel that they're confident they have the best case. But then the mediator, he will evaluate the case. He won't say which side is right, which side is wrong. What he will say is, here are your facts, here are the pros, and here are the cons, the strengths and the weaknesses. And if you don't settle this case and it ends up going to court, this is a possibility that you may lose because of these weaknesses. He's going to say the same thing to the other side. So a very strong mediation brief will help you convince the other side to settle. Now, this is probably one of the biggest problems that I have had in mediations. I handle mediations about 5 times a year. One of the main problems is the settlement authority. Many clients are overseas, and when they're overseas, they're not there at the mediation. So a lot of times they would have their agent represent them at the mediation. Well, when you have a client that is overseas, there's a time zone difference, as you know. If they're in China and Taiwan or Hong Kong, they're ahead of us at least 16 hours. So what happens is the client who's in another country, a foreign country, he needs to authorize somebody to settle the case, which means it's either the agent or another person that is there with the agent. It could be a family member, it could be a friend. Or he could authorize the attorney to settle the case. For instance, if there's a case involving $1 million property and the seller agrees to settle it for, let's say, $800,000, if the client is overseas and he does not authorize that amount and the attorney doesn't have authority to settle, basically all the time in mediation has been wasted. You see, in that kind of a situation, who has the authority to settle? Only the client does. Now, we don't recommend that the agent be given the authority to settle, because generally speaking, the agent is not the party to the contract. So what I recommend is that the client authorize the attorney to settle the case for a specific amount, let's say no less than $700,000. Or that we schedule the mediation to happen in a time zone where the client will wake up or will be available to answer a phone call on WeChat or on, I think my phone just went out. So we're just going to switch mics here really quick. Okay. Everybody hear me? All right,
Yes.
great. So it's very important that you insist on full settlement authority on the case. Now this is a very, very big issue. Don't get emotional or vindictive against the other party. Why do I say that? When people go into mediation, they bring a lot of emotional baggage with them. I'll tell you an example. Many sellers, they go into mediation thinking that they have to punish the buyer because the buyer breached the contract or the buyer had buyer's remorse, decided to change his mind. And they insist on taking the entire security deposit and asking for an apology from the buyer. The buyers aren't going to apologize. That is a certainty. There's no way they will write an apology. But they may sometimes agree to forfeit part of the deposit just to settle the case. Other times we may have buyers that are very upset against the seller because the seller failed to disclose something. The seller committed fraud. And the buyer wants to sue the seller, have a press conference. So when these kinds of emotions are involved, it's important that both sides try to calm down, take a step back. Like I said, mediation is not litigation. Mediation is a compromise. Don't think about trying to take revenge against the other party or being vindictive. The most important thing to remember is if you don't settle it in mediation, most likely it'll end up in arbitration or litigation. And in that case, you have to let the buyer know he needs to prepare to spend a lot of money to hire an attorney to go through the litigation process. Now, when you meet with the mediator, what will happen is you and your client will be in one room and the other party will be in another room, so there are separate caucuses. The reason why they don't tend to put both sides and all parties together is to avoid arguments. I have been in mediations where both parties have almost come to blows. Literally, they would get up and literally try to hit each other. And the attorneys would have to hold the clients back. And like I said, sometimes this could be a full contact sport. That's why it's very, very emotional. Now, when you meet with a mediator in a separate room, what you want to do is to prepare your client to give an opening statement, kind of a short summary about the case, why they're here, what they want from the outcome of the mediation, and how they want it to be resolved. A lot of times, the mediator will have already read the mediation brief from the attorney, but they want to hear from you and your client. And as realtors, most of you have most of the detailed knowledge. You know what happened in between the time when you represented the buyer and when the dispute happened. A lot of the times, the buyer or the seller doesn't know a whole lot about the details. So it's important that you help your client. And one way is to explain it with an opening statement. Now, after you've made the opening statement and the mediator has heard your side of the story, he's going to go to the other room talk to the other party and ask them the same thing. After that is done, then that's when the real negotiations begin. That's when you have to prepare to bargain. Try not to be too firm in your demands. When I mean bargain, what I'm trying to say is compromise. Be prepared to offer something, but don't offer your bottom line. So let's say you represent the buyer, and the seller decided he doesn't want to sell to you anymore because he got another higher offer. He wants to get rid of your client. So what you have to do is you have to tell your client, okay, let's start high. They don't want to sell to us, do you want to buy? If your client says, you know what, I decided I don't want to buy, I just want to take my security deposit back, then what you would ask for is the entire amount of your security deposit because you're entitled to it since the seller has breached the contract. Now, the seller on the other side may be happy to give the entire security deposit back because they have a better offer, okay? In that kind of scenario, if you ask for the entire security deposit and the seller agrees to give it back, then the mediation over, it's a done deal. But let's say you have another situation where the seller wants to sell to the buyer, but the buyer doesn't want to buy. For whatever reason, the buyer found another property. He wants his security deposit back. So if you're representing the seller, you would obviously ask for the entire security deposit as liquidated damages, okay? Or you could even insist that the buyer consummate the contract and buy the property. So the bargaining really depends on you and your attorney and also the mediator, how much influence you will have over the mediator. Try to convince the mediator your position. So like I mentioned to you before, settlement is a compromise. There's no 100% winner. A lot of times when we go into mediation, we end up with a result called a King Solomon. Does anybody know about the story about King Solomon in the Bible? Okay. King Solomon, according to the Hebrew Bible, he was an ancient king back in the old days, and at that time he would resolve conflicts by deciding who is right and who is wrong. He was like judge, jury, and executioner. So one day there were these two women that came to him, and they both lived together, and there were two children that they were raising. One recently passed away, and the surviving child, they were arguing over who was the rightful mother of the surviving child. So King Solomon, he was a very wise king, and he decided to trick them into revealing their feelings. He raised his sword and he said, well, I'm going to have to split the baby in half. I'll give one half to one woman and the other half to the other woman. Well, the first woman said, you know what, if I can't have the child, then nobody will. And then the second woman said, please, don't split the baby in half. Let her have the baby. So King Solomon knew who was the real mother of the child. Okay, in mediation, a lot of times you will get this result, a King Solomon approach, where nobody is happy. The mediator splits the baby in half and says, okay, you get one half of the deposit, you get the other half of the deposit, so on and so forth. That's why we say there's no 100% winner. If you don't settle it in mediation, you end up in arbitration or litigation, which is even more time-consuming and very, very expensive. Now, mediators, a lot of times, if they're very good, they can think outside the box. That is, they can think of certain ways to resolve a dispute with both sides walking away happy. And I've been in situations where some mediators are very good at doing that. For instance, a buyer wants to back out of the deal, and the seller says, you know what, I can't find another buyer. You have to buy this property. So what the mediator will do is he'll ask the buyer, do you have somebody else that's interested in this property that wants to buy it? The buyer say, oh yeah, maybe. I have a friend, he's very qualified, and he's also looking to buy a property. Maybe I can ask my friend. And so the mediator will ask him, well, make the call right now. He'll call his friend and he'll say, hey, I'm in this transaction. I don't want to buy this house anymore. The seller wants to sue me and take my security deposit. You want this house? And if the friend says yes, then the buyer can assign the contract to his friend, as long as the seller agrees. Now, these situations have happened where the seller will agree to let the buyer out and let somebody else in to the contract. That's one way of settling it. Another way is sometimes sellers will not want to sell the property because they haven't found another property to move. And they decided, well, if I sell now, I won't be able to find another property in this price range. I end up living in an apartment, and they decide I don't want to sell. So sometimes the mediators will ask the buyer, listen, the seller cannot find another property. Is it possible you can sell it to them, but lease it back for maybe 6 months to a year? And sometimes the buyers will agree. That's another way of compromising, of settling these types of disputes. So as I mentioned before, if you have a good mediator, he can think outside the box. And that's one way of resolving it where both sides are happy. But those situations don't happen quite often. Most of the time, based on my experience, both sides end up with a King Solomon. Now, if you don't like King Solomon, that's fine. You can pay an attorney such as myself $50,000 in legal fees and then go to court or go to arbitration. But as realtors, your job is to make sure that your client is happy with the sale closes, and you earn your commission. Going to mediation is no fun at all. You end up spending a lot of time and lost money in order to settle a case. But if you do have to go to mediation, these are the 12 points that you should be aware of. So that's pretty much it for my topic today. I'll be here towards the end of the seminar, and if you have any other questions, feel free to come up and ask me. Yes, another question.
Besides the real estate, do you handle some other arbitration, like such a family affair or divorce, something like that?
Yeah, I don't handle family law, unfortunately. I mainly handle real estate, immigration, corporation business.
Thank you.
Okay, no more questions?
Thank you very much.